Hello, good afternoon. Welcome once again to Covered Under Law. This is your legal light and help law in these trying times. I'm Samson Ladi Ayenini. Today we continue and we're doing part 2 of medical negligence. You ask us and we have got the experts to empower you on knowing first what constitutes medical negligence and what to do when it happens. Don't go anywhere. We'll be right back. You're welcome back. This is Covered Under Law. I'm Samson Ladi Anyanini, and thanks for joining us. We'll continue the very exciting and empowering education that we began last week on medical negligence. What exactly is it? And when it does happen, how can you get help? You yourself, what are you supposed to do so that you can get the needed help? And if you have to resort to the court, what can you do so that you don't get to the court and yet you have a good case and you still lose because you couldn't gather the evidence or preserve them? So last week, one of the aspects we said we'll deal with will be how to gather the evidence and preserve the evidence against, possible action. As you remember, Dr. Ernest Osudapa, who I will introduce you shortly, told us about treatment-related and lack of disclosure risks. That's how he put it. Treatment-related and lack of disclosure risks giving rise to medical negligence. He spoke about adjudicated medical negligence and also reported cases of medical negligence. And in the adjudicated situation, he spoke about cases that have gone to court, cases that have gone to Shraj, or some other place, including the Medical and Dental Council. And on that basis, he said the cases are very low. You have about 15 from the courts, you have about 10 as in reported cases so far. But what is reported in the media gives enough credence that medical negligence is rife. And then he made a suggestion, which he says during their research has been made and government is expected to pay attention and do something. First, a presidential commission of inquiry giving Ghanaians the opportunity who have had experiences in clinics and the hospitals to come forward and tell their stories. And medical practitioners also may come in, tell their stories, and in the end, we may get a good guide and a clear view of what is happening. Then there's also a recommendation for the medical ombudsman, a place just like Shraj, independent, where you can take your complaints. At Shraj, you take your complaints for administrative justice. So if you have been wronged in the workplace and so on, you can go to Shraj and you'll be helped. We know there's a labor commission. If you have been wrongly terminated and so forth, you can go there and they will help you. Matters of corruption and abuse of office, you can go to Shraj. When it comes to medical negligence or the practice, misconduct by doctors, we know that often it is the Medical and Dental Council, but it doesn't have the status of like Shraj or like the Labor Commission, which have the powers of a high court and can deal with cases, give you compensation, or go to court and compel certain things to be done. Now, Dr. Justice Youngson also helped us to appreciate that medical negligence, the way we see it, is not merely a question of careless acts, that it is more than that. He will continue on that level with us and also spoke about the fact that Ghanaians generally have the attitude of Fama Nyame, and therefore that may account for the reasons people don't go forward to take actions. However, some actions are taken at the level of the Medical and Dental Council, and even some people report their cases to his outfit, that is the Medical Association, and they now have to take the decision or determination to refer it to the right place for the right redress. I hope I have tried to do a bit of a recap for you. Now, let me welcome my guest once again. Dr. Justice Yankson is General Secretary, the Ghana Medical Association, and as I told you last week, he also teaches the law in this particular area. Thanks for making the time once again.
Most welcome.
Great. Also joining us is Dr. Ernest Owusu-Dapaah, who is Senior Lecturer and former Vice Dean, the Faculty of Law, KNUST. He's a member of the World Association of Medical Law and the Society of Legal Scholars. Good afternoon, and thank you for joining us, sir.
Good afternoon, Samson.
Great. So as I introduced Dr. Owusu-Dapaah the last time, I mentioned that he's the author of this book, Medical Negligence in Ghana, a primer. Right, so we are talking to the right people. So let us continue from where we left off last week. We got to know very clearly that the medical practitioner there's a certain standard of care or skill required of them when you go to them and make a complaint that you are not well. Now, if they, in their treatment, they exercise a skill which is less or care which is less than what is the standard, then it may occasion in medical negligence. So if they breach what is known as the duty of care, and due to that breach, you suffer a certain situation or injury, then a case may be established. Now, Dr. Yankson, before we left off, you were the one speaking, and you were referring us to a case, popular, well-known in Ghana, known as the Asante Nkramo, and you were using it to tell us a certain important point. Maybe we should continue from there.
Okay, so something, just for the benefit of our listeners, let me just recap what led to that.
All right.
We're just doing the breach and how more or less you prove it, basically.
Right.
So basically, with the breach of the duty, what happens is that you have a violation of some reasonable standard. It could be one that is set by law, or let's say from the profession itself. So it's a deviation from a certain standard everybody believes that it is the right way. And this deviation usually is conduct below the standard. Okay. So once this comes to the fore, then there are a bit of nitty-gritties in there. For example, if you want to base it on a standard, what do? We have a national standard or say a state standard. You go to America, for instance, because there are 52 states within that whole jurisdiction, you have different states sometimes having their own standards beyond what one may seem or may describe as a federal one. Of course, when you come to a state like Ghana, we may have our own standards as set out by law. Sometimes the standards will also be based on a certain specialized area you find yourself in. So depending on what specialty it is, the standards in there are what are going to be used. But if you are, say, a non-specialist, technically speaking, you will be judged for the standards of a non-specialist. But there's also this caveat that if you're a non-specialist and you elect to do what usually specialists are supposed to do because you have that knowledge, then you are going to be judged for a higher standard for the specialist.
Right.
So we need to understand these things. And usually, whilst you are trying to prove your case, there's also what we call the plaintiff and the defender. Usually the plaintiff is the one who is alleging. Now the onus is on you, generally speaking, as the plaintiff, to go out there and prove your case. He who alleges must prove. But within the law, under some circumstances, there's a presumption of a prima facie case that could be raised out of the facts that the plaintiff has presented. And that will result in what we term the principle of res ipsa. So the court will invoke that principle per the facts of the case as narrated by the plaintiff. And once that is done, then there's a reversal of who has to prove what. So the onus is then moved away from the plaintiff to the defendant to try and rebut that presumption of a prima facie case based on the facts. So in Asante Kremo and the AG, for example, this was way back in 1975. That was when it was reported, but the incident is was somewhere 72, 73. So it tells you how long litigation in this area has been, even in this country, like we said the last time. Now, in Asante Kremo's case, what happened was very simple. This was a 19-year-old lady who got married in the northern part of Ghana, was brought to Kumasi because that is where the husband lived. Now, she conceived, and unfortunately, she had a ruptured ectopic pregnancy, which is a gynecological and surgical emergency. So you had to, she was referred to Komfo-Anokye, and then the team or doctors on duty duly assessed, confirmed that there's been a ruptured ectopic pregnancy, for which reason they had to do an emergency surgical procedure to save her life. Surgery was very successful. Now, the ruptured ectopic pregnancy actually led to huge loss of blood. So in the process, intra-op, during the surgery, she was given some blood. And then post-surgery, when she was brought to the ward, she was to have further 2 pints of blood. Up until that point, everything had been perfect. The transfusion was left in the care of the nurses. For whatever reason, the case didn't really give a lot of the detail, but something went wrong, which is clear, resulted in the right arm of this young lady getting swollen, and subsequently it became gangrenous and had to be amputated. So post her discharge, she went home with just one arm, the left arm, and then she sued. Now, she sued Komfo-Anokye, but technically, in our jurisdiction, most government entities, the suit goes through the AG, so the AG is usually the defendant. So you see the case as Asante Kremo and the Attorney General. Now here, Asante Kremo narrated the facts per her pleadings, just as I have narrated, and then the judge raised the issue of res ipsa and took a presumptive position that a prima facie case has been established, for which reason the AG ought to explain. The AG here was the defendant, and it was very simple. This lady didn't come into your facility to do anything other than a surgical or gynecological.
When you say a prima facie case has been made, simply put, in looking at the judge looking at the facts of the case on the face,
yes, it's a presumptive.
it showed that something had in fact gone wrong.
Yes.
So the other party, which is the Attorney General, and the understanding here is that the Attorney General is sued because in this case the person is suing the state, and when you are suing the government or the state, you sue the Attorney General.
Yes.
Okay.
Yes. So the baseline was this. The judge asked a very simple question, that this lady came into your facility to have a procedure that has to do with her pregnancy. She came in with 2 arms intact. How come she left your facility with 1 arm? So Komfo-Anokye AG had to explain. Unfortunately, they could not give any meaningful explanation, so that presumption could not be rebutted. Okay. And they were fixed with liability. So the lesson here is that
fixed with liability means that, the way you understand it, means that they were held guilty. But if it's not a criminal case, we don't use the word guilty. So they were held guilty, like they have committed a wrong. and so they have to pay the necessary compensation.
Yes. Of course, I'm sure in the discussion we'll go into how some of the details in terms of how compensation is calculated and considered. So we'll look at it. But it was important that even in that case, some of the principles were expressed because it was the right arm, and she was also learning the trade as a seamstress. Right. So we'll look at those bits.
Okay. So a couple of medical doctors after last week's episode have sent me some concerns, and even some lawyers also have sent me some concerns. We will share them with you. We will dedicate sufficient time, then you bring in your questions or any contributions you have. After that, we will have our experts come in and supply you the answers. And one thing which is important we need to do, one lawyer who has done some of these cases and actually won them says that medical negligence is not difficult to prove. Many people think it's very difficult to prove. Here's a lawyer saying, with good experience, says it is not difficult to prove. The problem has to do with elementary mistakes made by the clients in collecting the evidence early enough. Collecting the evidence early enough. That's why I say we'll teach you how to collect the evidence and preserve the evidence in case this happens. Now, Dr. Usudapa, you graciously took us through the history of the standard of care, and you took us through 3 different cases and brought us to the very final point where the standard of care is not so much as in circumscribed, so narrow. If you can take us on from that last point where you left us.
Right. Thank you very much, Samson. And I agree with the views that Dr. Yangsen has so far expressed. But I also got a feedback that we sounded a bit more technical and legalist last week. So let's endeavor to speak to like non-lawyer or non-doctor audience.
I'm so grateful.
As it were. Yeah, so our endeavor to do that, so that we are speaking to the general public. So that is how I am pitching my contribution today. Yeah. So the point I was making was that, as Dr. Jansen said, that critical to a claim based on medical negligence is proving the breach of the duty of care. And to prove the breach of the duty of care, you need what we call the standard of care. In other words, there must be a reference point, like, or literally speaking, like a marking scheme, with which are we measuring the alleged conduct or omission of the healthcare professional with reference to what standard. So that if as you rightly said in your introduction, if the conduct falls short of what is expected, then there's a case of a breach of duty of care. And if it falls within that, then there's no case of a breach of duty of care. Now, with respect to medical negligence, there's a well-known case we call it the Bolam case. The Bolam case decided the very same year that we had our independence, 1957, somebody was going through electroconvulsive like the therapy, and the person was not restrained, and just using the electrical shock for therapeutic effect, and the person came off and then sustained injury and then sued. So the question which came up was whether in doing such procedures it is normal to restrain the person so that the person does not get off the table or the bed. So there was a divided opinion. Some doctors said that, well, if I am doing such a procedure, I will not restrain, I will not hold the patient tied to anything. Others said I will do that. So the judge, who was formulating the legal question for the jury, it was a jury trial at that time in the UK, was that insofar as there was a reasonable body of medical opinion or medical doctors who hold the view that they will have done what the defendant, that is the doctor, would confirm that if they were faced with the situation that is under investigation, they will have acted in the same way that the defendant doctor is doing. Then in that case, the doctor or the healthcare professional cannot be blamed because what they did is not something which is an isolated or which other responsible body of medical doctors will not do that. Now, this has been the problem which medical negligence, especially looking at it from the most of the common law jurisdiction, the UK and related jurisdiction, we find ourselves in. But later on, the courts have come to say that, yes, if what the defendant did will have been done by some other doctors, that is fine, but you are not going to stop there. The court must also find out whether the responsible body of medical opinion, in other words, what the other doctors are saying they will do, if you just oppose it with the whole circumstances, is it logical? Is it sensible? Does it stand to, logical analysis? If that is so, then the particular doctor who is currently being accused will have to be set free, cannot be held liable for negligence. So that is where we are. And doctors are like other professionals, but strangely, for other professionals, it may not necessarily be enough just for you to say that what I did, some other professionals who have done that, and that will be the end of the matter. If you look at the Bolam case, what it means is that if, for example, like a doctor was giving the case of maybe somebody with the feverish conditions and all that, and said, okay, he gave a prescription for malaria. And let's suppose that it was not really a case of malaria, but it was something else. And because of the malaria treatment, the particular condition he or she brought was not really diagnosed and treated, leading to some other complication and even touch wood, maybe fatality like death. Now, if later on there's a case of medical negligence against the doctor or the healthcare professional, going by the Bolam test or the Bolam principle, what it means is that if the doctor who has been accused who, for example, gets other number of doctors, can get significant number of doctors who will come and say that, yes, where a patient reports or such feverish condition in our environment, because malaria is so common, the first suspicion is malaria, and we have a standard protocol for treatment of malaria, and so I have done what this particular professional did. Now, if they testify to that effect, then according to the Bolam test, and of course, and also like the Bolaito, which says that the court should examine if it stands out to logical analysis. So long as the other doctor's testimony, for example, has not been demonstrated to be illogical, then this particular doctor will not be found liable for negligence, because what they did, other doctors, responsible body of other medical experts who have done the same thing. So that is the situation with the standard of care as far as medical negligence is concerned.
All right.
And it has not really changed much, except that when it comes to disclosure aspects, the UK Supreme Court, the Montgomery case I mentioned last time, is suggesting that it's not just a question of what other doctors will have done, but more importantly, what a reasonable patient, like a patient in the shoes of the particular patient in question, will have liked to know in terms of what he or she would like to be told about the diagnosis or about the treatment options and so on.
Right.
So that is how we work out the standard of care.
Okay. So remember that when Dr. Osudapa spoke last week about the lack of disclosure of risk, which also may lead to a case of medical negligence, he gave an example that in a case where someone didn't tell the patient the potential risk they are likely to suffer if they went through a particular medical procedure. And it was about delivering through the natural way or the vaginal delivery or the CS. And
yes,
the doctor did not take the time to tell the patient that if you go through the CS, this is likely, these are the likely risks that you face. And in your situation, if you wanted to go through the natural delivery, these are the likely risks that you face. On the basis of that, and something happening after the procedure was undertaken, someone could be held liable. Now, Dr. Jansen, last week there's something you tried to bring our attention to. And there's another doctor who got in touch with me and looked at the question of the standard of care and the scale. In our part of the country where majority of you are in, say, state, facilities, we have had situations where you are in the theater, you are doing a surgery, and then the light went off. There's a certain machine that you need to make your work a lot better. You don't have it. Or a delay that may have occasioned the death or caused certain injury to a patient may have been caused not because you, the doctor or physician who's standing on the patient or the practitioner, is your fault, but it came through like the system. You sought to point us to that. So another doctor also said we should pay a bit more attention to that, and then get your comments on that. What will you say?
Okay, so Samson, I mean that's a very important area, and it is one that sometimes can actually make matters a bit more difficult. But in truth, the judges are always, smart and alive to the details of the matters, and they will deal with it per the merits of the case. So like I said earlier, or last week, usually if a lawyer is taking an action, you sue the employer, as in the establishment, so the facility, before as the first defendant, and then the healthcare professionals will be the second, third, The employees are deemed as men of straw, generally speaking. The employer is the one with the resources. And in this particular exercise, when you sue, you are in for compensation.
That's
and
right.
It's usually monetary. So you go for the jugular, let me put it that way. Now, what happens is that usually these things happen just like my colleague also described. But if it should go before the courts, the courts will break the facts down, segregate the causation, and be able to see that up to a certain point, based on the evidence available, the doctor or the practitioner involved had done what was right. What occurred, like an intervening factor, i.e., the electricity going off, no backup generator, stuff like that, for which reason the anesthetic machines and all of it couldn't work, they lost the patient. The courts will usually take a hard stance view of those bits, especially where it can be proven that these are things that have been brought to the attention of the employer or the owner of the facility, and they have had ample time to actually correct these things.
All right.
If they fail to do and has resulted in, let's say, a death, which ideally was preventable, the judges can actually take a hard stance against the employer.
All right.
But the professionals will be set free.
Okay.
Or sometimes what will happen is that the judge will say that in its totality, the establishment is liable. They are guilty in court, like we said.
Right.
But they may take a decision that will mitigate the punishment because it was so clear that, but for the events that were beyond the control of the doctors, this wouldn't have happened.
Right.
But once they break the details down, by and large, the doctors will be set free,
okay.
but the establishment will be held responsible.
Thank you.
But let me just add this. You see, these are some of the things that you hear the professionals always preach against, because it goes back to hurt the ordinary man. And ultimately, the employer will still have to pay more. So why not fix the problems as and when they occur?
Right.
And the states, per our constitutional injunctions, are mandated to ensure that the people of Ghana get good health care.
So
if you have health facilities, the state should pay a lot more attention to them.
Thank you. Right. So you're here on COVID and the law. This is your legal light and health law in these trying times, and we are dealing with the issue of medical negligence, empowering you by education so you understand and can identify what medical negligence is, when it happens, and how to pursue a process of seeking closure, including compensation in the circumstance. So last week we dealt with medical negligence. We told you what medical negligence is and how it manifests itself. There is medical product liability, failure to warn or advise a patient of associated risk, which we just mentioned a while ago. You may be providing the correct diagnosis to a situation, but if you do not provide it in a timely manner, it may also result in medical negligence. If you made errors in prescriptions or medications, if the physician made errors in prescriptions or medications, it could also lead to a question of medical negligence because they have refused to exercise the skill that is required, the duty that is required of them, and as a result of that, you have suffered a certain injury or death has occurred. Also, they may be performing medical treatment or surgery without reasonable care or skill. Now, Dr. Osudapa, we want to know, last week we asked a question, who can sue? We want to know, in some of the situations, the person whom the malpractice or the wrong thing has been done against is dead. So who can sue? If it's against me, I know that my arm is amputated. I didn't go for arm treatment. I went with headache, and then I came out with my arm, gone. So I know that I can sue. But if it happens that way, who can sue? When does the law say I cannot sue? I have lost the opportunity to sue.
Right, thank you, Samson. Before addressing that, if 1 minute, if you allow me to,
please go
just
ahead.
Add the discussion to Dr. Yangson's point you developed. Yes, I appreciate the difficulty with which the courts may have to come to a conclusion that health facility, and for that matter, healthcare professional is liable for medical negligence in the circumstances that we find ourselves. For example, I have some medical doctor friends who called me after last week's program telling me that I attend to 70 patients in a day. I don't have this, I don't have that, and we are trying to do the best we have in the circumstances. So why would you like to bring the same legal standard in developed world, where we have maybe just one doctor attending to maybe 30 or 20 patients in a day to in our environment? Yeah, I mean, that is a legitimate concern. And that is why I have suggested elsewhere that in order we need to evolve what we call a unique solution to the problem of medical malpractice we find in our unique circumstances. And what do I mean by that? I will advocate for a limited scale, a scale of what they call that, the no-fault compensation scheme for medical negligence in Ghana.
No-fault compensation scheme.
And this should go alongside the patient's ombudsman. Yeah, no fault compensation scheme. So if we have the, let's say like the patient's rights ombudsman or the medical ombudsman or however you call it, then it should also be given the mandate or the jurisdiction to administer a no-fault compensation scheme. If you have a no-fault compensation scheme, it's going to bring about more honesty and transparency in reporting of errors, medical errors in our health facilities. Otherwise, if some of us are supposed to do aggressive medical negligence litigation in this country, there's going to be what we call the defensive medicine, the situation in the US. And defensive medicine is very difficult. Defensive medicine is a natural response to what we call the medical malpractice litigation crisis, because everybody would like to cover his or her back. And this will bring about unnecessary lab tests, a lot of scanning, like certain things which ordinarily are not really necessary. You can still arrive at a diagnosis and make some treatment prescription.
Okay, so who can sue, and when does the law say you cannot sue? You have lost the right to sue.
Okay, so where the victim of the medical negligence, for example, has died, as you said, then the cause of action does not die with him. The cause of action does not necessarily die with him. For example, when it comes to medical negligence, a personal injury, and under the limitation of actions law, usually have 3 years.
Right.
So that if you have suffered maybe medical negligence, you have 3 years from the time that it occurred to come to court or go to SHRAJ or probably go to Medical and Dental Council to seek a remedy. If you don't act within that period, then it may become a statute bar. So let's suppose that the victim died, and the victim died before the expiry of the 3 years. Now the dependents and those who are in charge of his estate, the personal representatives, usually, when someone dies, you have to go for what you call the letters of administration. If the person, for example, did not make a will, or go for probate, asset will, and so on and so forth. So you get the letter of administration or the probate, and then it will enable you to become the proper personal representative of the deceased, and you'll be able to bring up action on behalf of his estate. But for the dependents, let's say like the dependents of the deceased, those whose welfare was the responsibility of the deceased, they have a right to also take up the medical negligence which led to the death of the deceased. The reason being that if the disease, for example, had not died, or if the disease had not been rendered incapacitated and all that, they were going to benefit from the sweat of the victim of that medical negligence victim.
Right.
And again, sometimes too, the information which you need to be able to bring up medical negligence claim may be such that it is not readily available. Let's suppose that you went for a certain procedure and they left a scissors or they left something in your body, and you'll be getting certain symptoms later on, but you are not able to link it. You are not even aware that something was left as a result of the last surgery that you underwent and all that. So let's suppose that you go to another facility later on and they are doing investigation and they discover something. And that thing that they have discovered, you can link it to certain health conditions that you will be having. And if there is that positive link, that nexus between, let's say that the error that they made and what to be going through. Now, what it means is that this material information will have been discovered later on. The 3 years might have even elapsed. But the law says that if you subsequently become aware of the material information, which would enable you to bring up a claim for medical negligence, then you have 12 months within which to bring the action. In other words, if you become aware eventually of that particular information, which lets you know that, yes, you've been a victim of medical negligence, then within 12 months of becoming aware of that, you must go to court. Otherwise, you will lose your right of action. Or lawyers will say that will become like the statute bar.
So in that case, the 3-year standard doesn't apply?
No, the 3 years does not apply. But you need to go to court to make an application.
Right.
Seek leave. In other words, tell the judge that this particular information was not available, could not have been known by you until now.
Thank you.
And then the judge becomes convinced. And the judge
now we are inviting, we are going to let Dr. Usudapa relax a bit and then get your questions. If you have any questions, this is the time to bring them up. We'll take the questions for a while and then we'll let Dr. Usudapa return to assist us to give you the answers to the questions that you have to ask. We will ask also deal with the aspect of what goes into the compensation. If the court has to compensate relatives of someone who is dead as a result of medical negligence, how do they go about it? How much you get? How much is sufficient? How does the court do some of these things? Right, so as you see, our Zoom ID and password, they are available to you. You can come in now and let's hear your questions. The Zoom ID 9750634818014. The password is 607789. Let's hear you. And Dr. Usudapa suggests the no-fault compensation scheme, which he says will also boost, honesty within the system. I'm sure that's something that for physicians like you, you're happy that if it's in a system, it helps.
Well, I mean, it helps, obviously, but the situation is this. No matter what you do, it is not going to be a one-fits-all solution.
Of course, of course.
So all the bits that can come in and ultimately ensure that both...
Once somebody has suffered, we have an institution that will give you something by way of compensation.
That's what I'm saying.
They don't have to say the doctor has committed some error somewhere, no fault.
Yes, once it is determined that this has occurred, and the state has structures in place, it reduces litigation and what have you. You know, Dr. Usudapa mentioned the issue of defensive medicine. It's a very important thing. Look, in the year 2003, the former US President, George Bush, said, this was at the American Medical Association, General Conference, said that, look, there are too many frivolous lawsuits against good doctors, and the patients are paying the ultimate price. What has happened is that because of the risk of litigation, the doctors, to avoid this, even where clinically they can establish a straightforward diagnosis, they will ensure that you do all the related investigations, which can be very expensive. But the cost will be borne by you, the patient. So ultimately, you realize that as we push the frontiers of litigation as far as medical negligence is concerned, these are some of the things that will come up. So if we have schemes like this,
you acknowledge.
Yes, it's important because either way, it also helps the practice. Because in this era that we find ourselves in, medically we describe it as the era of evidence-based medicine. So it helps. But let me just add a little bit to the 3-year bit. Just as Dr. Dapa said, the 3-year rule is there, but the interpretation of it sometimes we need to understand. He mentioned one of it clearly, that from the time it occurred. The second one has to do with...
So like I said, the Zoom is open now. You can come in. Let's hear what questioning you have for our experts. And if you have some contribution, but keep it very straightforward and simple, very short.
Yes. From the point at which the injury occurred, the other side of the interpretation of the 3-year rule is that it is the point at which it came to your notice, but still within the 3 years. We haven't gone outside. Because if, let's say, the injury happened today, but it occurred to you after, let's say, 6 months, that, oh, indeed, what has happened was actually as a result of the injury. The supposed negligence. Your 3 years will start counting from there. Then the exception that he said, that if you've gone past the 3 years, then you have 12 months to put in. There's also another bit for minors, because minors also suffer these problems. So a minor at age, say, 15 years or 14 years may suffer some medical negligence. The law's position is that they still have time up to the age of majority, 18, if nobody has sued on their behalf. So upon turning 18, their 3 years starts from there up to 21. So 18 to 21. Within that space, they can still come with claims, even though if you add the figures, it would have been 7 years. But because they were in the minors category at the time and nobody sued on their behalf, once they turn to the age of majority, 18, and they know that this is what has happened, they can go and sue. Yes.
Okay. All right. So this is covered under law, and we are treating medical negligence, empowering you with that medical legal education so that you know what to do if it does happen. And you can first identify that it has happened and then what to do. As we wait for audiences to come in, I understand we have a little difficulty. Please forgive us. We deliberately planned that today you will come in. So forgive us for what is happening now. How do I collect the evidence and preserve it? Because as a practitioner myself, I know how difficult sometimes it can be that the people have a clear case of medical negligence having happened, but all the evidence is with the hospital. And any attempt to get that evidence, then processes start to destroy it so that you don't even get it.
Yeah, that is a very tricky area, I must confess. Unfortunately, evidence is one key component of any litigation process.
It's the name of the game.
It's the name of the game. If you don't have evidence, you can't do it. But in some situations, the evidence is pretty straightforward because the obvious, effects of the wrong are clear for everybody to see, like anti-criminal. But in some situations, you need to go into the medical records to be able to actually know what actually went wrong. And this is where the issue of confidentiality, disclosure, and others begin to come in. Now, for you as a patient, the hospital knows, technically speaking, are the property of the hospital. That has to be made clear. But you, the patient, you have a beneficial interest in that. So you can actually apply in writing to the health facility, stating exactly what you want. And it will be given to you either in full, by way of, say, photocopies, if they so wish, or a printout of all your relevant medical records, or a summary written and duly signed by authorized persons within the health facility. If it is still not good enough, and you realize that clearly there are difficulties trying to assess the rest of the evidence you need, through the courts, orders can be given for the health facility to produce all the records.
Right.
Yes. So in as much as it is difficult, you also will need that. Right. The other side of it is that sometimes you also will need good witnesses in your case.
Right.
Sometimes you may even need expert witnesses.
Yeah, you may need other doctors.
The position of expert witnesses are not binding on the courts, but the courts will evaluate them and may take a decision based on some of them. So it's a difficult area, but we need to. But the key here is that if you are a patient and you happen to have any evidence in your possession, you are better off keeping it safe.
Right. So how can I? And I want to apologize to you because of the difficulty in joining us. I want to apologize to you. What we can assure is that we should be able to have you bring your questions in the next episode, where we are going to have the Medical and Dental Council to tell you how they treat these matters when they come before them and what you may be able to do. We just have run out of time within the period that we have been trying to get you in. Forgive us, it's a technical situation that we face. So what can I do personally in trying to collect the evidence whilst I'm becoming suspicious in the process, so that if I need to take a step, I don't have to rely on the hospital I'm going to sue and the doctor I'm going to sue for the evidence I need?
Okay, so sometimes it's difficult because until the outcomes, you as a patient, you might never even think of negligence.
That's right.
So in the course of the processes, you may not have kept. But there are certain key things that we all need to look out for. For example, issues relating to consent and patients' rights generally.
Okay.
That is why the Patients Charter, as found in the Public Health Act 851, is very important. We also need to know these things as patients so that we can exert our rights.
That's right.
That is key. Now, once the processes are happening, for example, consent for a surgery, it is very, very important that consent is given before surgery. It is a must. Now, we are not talking about just consent. We have moved from just ordinary consent to what we call informed consent.
Right.
Now, by informed consent, what it means is that the health professionals or the facility has to communicate with you properly in a language that you understand. If there is a need for you to get interpreters or people who...
That's where they tell you all the risk
and everything.
What you are going to do.
They give you the opportunity to also ask questions.
Okay.
And then ultimately, you are satisfied that indeed...
What is going to be done?
A printout will be given you. You also have the right to read it or take it home.
All right.
For other people to look at and guide you before you sign.
Many people, they get the prescriptions, the doctor writes something for them, they throw it away the next day, or they go to the pharmacy and they take it, give them the drugs, it doesn't get back to them. Shouldn't they find a way making photocopies of all of these things?
Truth is that there are people who keep very good records. It's all about record keeping.
Right.
Others don't. Look, there are people who, until they have finished reading the literature attached to drugs, whether prescribed by a doctor or dispensed by a pharmacist is not the issue. They will read and be sure that it even fits what they discussed with the doctors.
All right.
So it's all about us as a people trying to ensure that we document properly and keep records. It's very important.
Unfortunately, this is how time really runs when it gets really very interesting. But this is where we draw the curtains on part 2 of medical negligence. And having noted your immense interest, for good reason, we will endeavor to get the Medical and Dental Council in the studio for our next installment, and then give you the opportunity once again to ask your questions. Maybe we can plan it so that we even start the show with you, so we don't encounter the technical difficulties we presently have, for which you have not been able to join us. Thank you so very much, Dr. Justice Youngson and Dr. Ernest Owusu-Dapaah. Thank you so very much. I'm Samson Ladia Yanini. Have a good afternoon.